When it comes to whether or not a judge must recuse themselves, a recent example has raised a question that I don't think I had thought of in the past. But what if you appointed the judge yourself? Does that create some type of conflict of interest? Should you then become a litigant before that very judge?
It's a really interesting question. It's not one that there's real case law on, at least to my knowledge. So I don't think it's a question that's actually been tested, at least in any deep way. I think how you would think about that question would be to look to the Caperton standards, which would say, would a reasonable person looking at the facts in front of you say that there's a serious risk of actual bias under these particular circumstances?
That was Caperton v. Massey?
Caperton v. Massey was a case coming out of the West Virginia Supreme Court. And in that case, so West Virginia is one of 38 states where judges stand for election as part of their system for choosing judges. And in West Virginia, you had a multi-million-dollar verdict that was on track to be appealed to the West Virginia Supreme Court. And at the same time that appeal was pending, you had a judicial election going on. And what happened in West Virginia was that one of the litigants, the owner of a company involved in that multi-million-dollar verdict, poured over $3 million into that state's judicial election. Wow. He created a PAC with great name, For the Sake of the Kids, and that PAC spent $3 million in support of one of the justices' elections. The justice won that seat and ended up being the deciding vote in overturning that multi-million-dollar verdict. And the justice, there was a request that he step aside from the case, that he recused himself, and he said no, because I think I can be perfectly fair and unbiased in making this decision. It went up to the U.S. Supreme Court on due process grounds. So not just kind of what does the law require, but what is the bare minimum for constitutional fairness in a trial. And the Supreme Court said that in this instance, there was a due process violation, that in this instance, the due process clause of the Constitution required that justice to step aside from the case. And the legal standard that the court established was that when there is a serious risk of actual bias, and again, not based on a judge's subjective view about whether or not they're biased, but if somebody looking at these facts could say there's a serious risk of actual bias, then the due process clause of the U.S. Constitution requires that judge or that justice to step aside from the case. And so that case was sent back down to West Virginia, and a very important precedent was set. I think as a general matter, just for the run-of-the-mill appointment, the run-of-the-mill case, I don't think that there would be I don't think that standard would likely to be met. There's certainly no rules in the code of conduct or in the relevant statutes that explicitly require recusal because you were appointed to the bench or nominated to the bench by a litigant. But I think you would still have those due process protections and those kind of catch-all protections about what would a reasonable person think, that under the right factual scenario, it's possible that there could be a concern about bias.
I mean, without going too much into detail, I wonder if we could make a quick application to the case in Florida involving President Trump. Here, it wasn't, I may be mistaken, but it wasn't that he appointed a close personal friend, but he did appoint Judge Cannon. If you were giving a quick analysis, I don't know, if you're guest lecturing on con law, what would be some of the things that you would be weighing as you looked at that?
Well, I think as a general rule, the simple fact that President Trump nominated Judge Cannon to the bench would not be enough to trigger any kind of recusal requirement. And, in particular, I think the fact that the Senate plays an advice and consent role, I think would further distinguish this case from Caperton, because there are kind of multiple players. There's multiple layers of involvement and participants in the process of a person actually reaching the bench. I think that the questions that you would want to, if you were raising a recusal claim, the sorts of facts that I think you would be looking at would be, was there something, was there any assurances that she was made or was asked to make about how she would approach cases that involved President Trump? Did she make any promises? Was she asked to make any promises? Did the president say anything about her and her nomination that suggested that he expected that she would protect his interests? So I think you would be looking at those sorts of facts that would to help assess, would a reasonable person think that there was a serious risk of actual bias here because of the relationship or because there was a particular, debt of gratitude at play here. I think generally speaking, the mere fact that he nominated her, though, wouldn't be enough.